Hey everybody, Matt Johnston here, Matt the Lawyer, and we're going to be talking about the Americans with Disabilities Act a little bit today. Before we get started, if you like these videos and you enjoy listening to them or watching them, please hit the subscribe button. You're going to see it up here at the end of the video. And other videos that you may be interested in, you're going to see a link to up here on this side of things. And if you want to get a notice when we publish new information, be sure you hit the little bell down there to subscribe. So most people or small business owners or business owners who are familiar with the Americans with Disabilities Act usually interact with it with Title I, which involves accommodations for employees. But equally important to physical places is something called Title III of the Americans with Disabilities Act. Now, our friends in Congress, when they wrote the Americans with Disabilities Act, there wasn't a whole lot of websites around, and that's what we're talking about here. In a case out of Florida, a gentleman who was visually impaired, not fully blind, at least according to the facts that I have here, sued Winn-Dixie grocery stores, which is a grocery store chain down in the South, arguing that their website for the pharmacy was not ADA compliant. Now, Title III of the ADA covers public accommodations. Now, these are things that are generally accessible to the public. So think hotels, restaurants, airline services, transportation services, things that are available for the public to use that the owners of those businesses cannot discriminate and may need to provide accommodation. So this is why you see places that have, for example, wheelchair ramps, or, and probably what is the funniest thing I have ever seen, Braille on a drive-up ATM. So literally, this used to crack me up. I would drive up to the ATM at my bank and there is Braille on the thing, which made me sort of wonder what blind person is driving. But that's neither here nor there. So public accommodations are required to provide accommodations for those who are disabled. And a big issue that is common is whether or not websites are accessible to those who particularly are visually impaired. So that's sort of the underlying dispute here. Is the plaintiff in this case alleged that Winn-Dixie's limited use pharmacy website was not ADA compliant. And the court ruled that his claim that the website has to be ADA compliant was not accurate. So the court ruled that the website does not have to be ADA compliant. And there are some very specific facts that are involved here. So the first one, and I'm going to read here from the court's decision, says Winn-Dixie's limited use website, although inaccessible by individuals who are visually impaired, does not function as an intangible barrier to an individual with visual disability accessing the goods, services, privileges, or advantages of Winn-Dixie's physical stores, which is the operative place of public accommodation. Specifically, Winn-Dixie's website has only limited functionality. Most importantly, it is not a point of sale. All purchases must occur at the store. Further, all interactions with Winn-Dixie, which can be, although need not be, initiated on the website must be completed in-store, prescription pickups, and redemption of coupons. And the court goes on further from there. Now, I think one of the key factors that we're dealing with here is a limited use website, specifically that this particular website allowed pharmacy patrons to renew their prescriptions online. And then they still had to go into the store in order to pick up the prescriptions, pay for the prescriptions, redeeming coupons, those sorts of things. So the actual transaction still took place in the store. And I think that's why the court ruled that the website did not have to be ADA compliant. Now, why am I saying this? Well, first of all, I believe that if you are operating a website, you probably at some point are going to need to make sure that it is ADA compliant. And that's not, there are some information and some things that are available out there, but you really should be working with an expert in making things ADA compliant. You can't just slap on a plugin or something like that to get everything that you need to be done in terms of compliant for ADA purposes. There are lawsuits that are being put out there. Some of them are on the surface seem a little humorous. There is an attorney who has specialized in suing porn sites for not being ADA compliant for the visually impaired. If I recall correctly, the lawyer himself is visually impaired, and he's been suing porn sites for not having ADA visually impaired accommodations available for it. The specific Title III issue at stake here is that a physical store has to be ADA compliant. There has to be accommodations for those who may need special accommodations to deal with disabilities. But they all have in common that they are physical brick and mortar places. Going forward, do not be surprised if Congress starts to make some changes. So many of our businesses are now premised upon the idea of being able to engage with them online. Amazon famously, other stores, even small stores that have an online component are going to have to be physically capable or have accommodations for those who are physically incapable, particularly those who are visually disabled. So I do imagine that if you are in that situation now as a public accommodation, if your website is not ADA compliant, meaning accessible to those who are visually impaired or other impairments, you are going to have to make that change. Now, the case out of Florida has set up what is referred to as a circuit split, or it's made the circuit split a little bit bigger. That's lawyer speak for this is a case that's probably going to make its way to the Supreme Court at some point. I do believe that this case could eventually be the one that makes it to the Supreme Court, where the Supreme Court is going to have to address whether or not websites are specifically covered under the Title III of the Americans with Disabilities Act. Some circuit courts of appeal have said no, some circuit courts of appeal have said yes. So unless Congress acts to change Title III of the ADA, it's going to be up to the courts to determine whether or not websites are covered under Title III. We're going to put some resources down below. There is a client of mine who specializes in putting together websites that are ADA compliant. No, I get no benefit from this. She doesn't even know, at least yet, until she reads this, that I'm going to be referencing her. And so, yeah, while I would appreciate you sending your business to her, and I'm sure she would too, it's not something that you're required to do, and please don't infer anything from that. But if you are working with a web designer, you want to specifically ask if it's going to be ADA compliant. In the meantime, we'll be back with some other videos soon. Be sure to hit the subscribe button up here and check out some of other content here. And you can always go to our website at mattthelawyer.com to check out more content. In the meantime, stay safe out there and go out and watch some live soccer. Talk to you later. Bye-bye.